All righty, let's welcome our next guest to the Dan Hammer Show here. Ashley Cook is a mobile security expert, and Ashley, it's amazing this story: Apple versus the federal government, consumer privacy versus national security. It has a lot of legs day to day in talk radio, no matter where you are in the country. and people have strong feelings about it. And it seems like right now, at least from what we hear anyway, in this region of the country, the numbers are similar to what I saw with Pew Research a year ago, that about 54% of Americans thought, you know what, even in the context of national security, if it means I'm losing less rights, privacy rights when it comes to my cell phone and internet, really I'm not for it. And it seems like that's kind of the majority, even if it's slight majority opinion at this point. What are you hearing, Ashley?
No, I agree with you. I mean, it's kind of parallel to, all right, well, when I go home at night, I lock my front door, and I know that I have a key and my family members have a key, but the police department certainly doesn't have a key to our house. So I feel like in this context, what they're asking is that Apple circumvent the encryption, which is the user identification number that we all use when we log in on our phone, that they circumvent that so that the federal government can have access to the information. Mm-hmm. And I just think that that's a very far overreach of where we should be.
Following San Bernardino, President Obama urged, law enforcement leaders in Silicon Valley and high-tech people to try to reach some middle ground. This is the first real test of this. And tell us about the historic nature of this test now between Apple and the federal government.
Well, this case marks the first time that a judge has questioned the authority of the All Writs Act. Now, basically, the All Writs Act is an act that allows the court to issue an order to effectuate a prior order authorized. So essentially, if there's a search warrant, then this act allows for a third party to be compelled to turn over that information. But where we're stretching in this circumstance is that it's not saying, you know what, we want you to turn over the information. We want you to actually do something, do work for the government in order to extract the data and circumvent the encryption and the password protection. So that's where this is very interesting. And it's interesting that the judge has enough of a sense that, you know what, we may be overstepping for him to ask Apple and allow them to address the issue.
Mm-hmm. Because what the judge basically is asking Apple to do is to develop a piece of software or program to get into the encryption of the phone. And the Apple people are saying, well, it's either too dangerous to create or we don't have it. That has been their response to this point, correct?
Absolutely. But also, I mean, there's some constitutional issues. So, number one, can the government force Apple to write code? Code can be considered speech. So we have some First Amendment issues where is this compelled speech? Mm-hmm. And I think that, there's a good argument that this is absolutely compelled speech and therefore unconstitutional. Number two, how much burden does this put on Apple? In the sense of, we have a company who goes to great lengths to protect the consumer and their users by giving them the right to lock their information with their user ID, their password. And what the government's saying is, you know what, we don't want you to have security measures in your phone because we want to be able to use a backdoor to access the personal information. Now,
those who would argue the flip side might say, well, how can this be an overreach when really we're talking about one phone, one situation right now where investigators try to find out this time hole that they haven't been able to figure out yet following the San Bernardino terrorist attack. So some will say the counter-argument is, how can it be overreaching when they're really trying to focus on one particular phone, one piece of encryption, and leave it at that? Is that a fair argument?
You know what? I think it's a short-sighted argument because it all starts with the first time, right? So it's one phone, but I think that here Apple's gone to great lengths to build their iOS 8, for example, and so that platform enables that user ID to be owned by that individual so that Apple does not have that. What the government is asking them to do is to build a code that will enable them to circumvent that user ID. So if it's just one code, one phone, you know, there's other means by which the federal government could obtain the information. I think that, you know, we've seen that there's other hackers that have said, hey, you know, let us do it. Mm-hmm. The way that they're going about this is unconstitutional, and it's a breach of our privacy. So I do think that security is important, and it's a very serious issue. But at the same time, we have to look at what cost. So going back to, do I want the federal government to have a key to every person's front door? Mm-hmm. Right? Just in case, no. If they're going to need to enter my home, then they should go through the proper channels. So I think it's just that slippery slope. In this case, we don't want it to set a precedent to whereby the federal government could force a private company to assist the government in a circumstance where there's a complete disruption of their service. And as part of the offering of their business is we build technology that's secure.
The federal government is probably not surprised by Apple's reaction, especially if they were familiar with Apple's privacy stance. And they have a dedicated webpage on their privacy stance, and it's pretty strong language from Tim Cook. And it says, I want to be absolutely clear that we never have worked with any government agency from any country to create a backdoor in any of our products or services. We have also never allowed access to our servers, and we never will. That's pretty clear.
That is very clear. You know, one other interesting thing when we're talking about the boundaries of the government is that Congress has pushed back at this. So when the Communications Assistance for Law Enforcement Act was passed, that they dealt with this. You know, how far can law enforcement go to infringe? And they exempted information services, which, you know, include some of the services that Apple provides. Mm-hmm. So that's the other issue is that, you know, if we're going to stretch the law, then, you know, then let Congress do it, the legislatures, and they've repeatedly pushed back on that. So I think that's another important point to make.
So when the president talks about middle ground, or he talks about getting some help from Silicon Valley in situations like this, is middle ground reachable here, or is this just flat a black and white argument, consumer privacy versus national security?
You know, I got to say, I believe the middle ground is that there's nothing stopping the FBI from hiring people that are talented that would have the ability to go in and either through social engineering determine the password or hacking. And I think that is what should be happening. The federal government should be hiring people so that when we have a writ or we have a search warrant and the federal government, the FBI, seizes someone's cell phone, they should have the means to go in and extract that data and not force companies like Apple to do the work for them.
What's the end game of this current situation, Ashley? Ashley Cook, mobile security expert, visiting with us today. What's the end game, Ashley?
Well, I think the end game is that we're going to get some clarity on where this country is headed with cybersecurity and, you know, what is acceptable and what is not. And I certainly hope that that we stay in a position where we respect the privacy of our citizens and that the government use the proper channels, which it has today, and that need be, that there be legislation to allow, actually, I don't even think they need to change the legislation. I really just think that the government should not be forcing private companies to extract data.
Right. Now, you're making the argument if such work is to be done, it should be the responsibility of the FBI to do such work and not to be asking a private business to do so.
Yeah, because now you're forcing you're forcing private businesses to be agents of the government, and they're a third party, and they shouldn't have to do that. That's a violation of the Constitution. If they get a search warrant and they want to seize the phone, and by all means, if the FBI has the talent to have people break in and unlock the phone and pull and extract the data, then that's what they should do instead of having the courts force private companies to do that work.
Ashley, thanks for a little clarification. Ashley Cook, mobile security expert, joining us today. Ashley, thanks for your time. Have a great weekend.
Thanks. You too. Take care.